The UNH team for having us here for such a great day. So our panels agreed to take the 75 minutes, keep the last 15 minutes for questions and answers and observations, and then to divide equally the remaining 60. So we'll each speak for about 20 minutes. In my time with you today, I want to pitch the idea, although I may be preaching to the converted, but I want to pitch the idea that summary judgment motions are not only a good vehicle for teaching persuasion, but actually could take the place of appellate briefs that we write. So I guess I should start with a quick poll. So how many of you use summary judgment motions when teaching persuasion? So I'm preaching to the converted. Okay, well, this is a soft sell. Okay. Well, I come to this, and we'll see what you think. So actually, I'm really looking forward to your observations. I should also start as a preliminary matter. If you want to ask questions that were going along of me during my presentation, please do. I really prefer that. So I'm thinking about, post-Carnegie, right, where we keep talking about best practices. And so there's been lots of focus on what we're doing in our curriculum. And then post-financial crisis and big law restructuring and the impact on mid and small law, we're specifically focusing on how our students ready are taking their skills, values, and knowledge that we're teaching them, how are they ready to put them into practice when they arrive there. And I think that one of the key advantages of doing what we do is that we have a long track record in thinking both I think consciously and conscientiously about what we give our students to use when they leave our classrooms. We may not have the big bucks or the big perks or even the big status, but I think what we do has the big payback value in going forward post-Carnegie because our skills are the ones that are being focused on right now. So when I think about teaching persuasion, I have to tell you, I put it in the context of that didn't get, there we go. And using summary judgment. I put it in the context of, I'm supposed to say here, the VLS 3-semester program. So we have a 3-semester required writing program that begins in the first semester, first year, with what I think of as classic legal writing 1, research analysis, and objective or predictive writing. I always say boot camp, but here it is. And then second semester, what we do in legal writing 2 is that in different substantive areas that each professor chooses, we do a capstone predictive writing experience and then move on to preliminary persuasion is how I think of it. And that's where the summary judgment motion comes in our curriculum. In the third semester, we do appellate advocacy. That's required, 3 credits. But the way we do it is we use a pending U.S. Supreme Court case. We each choose our own, tee it up, and the students advocate on both sides of the aisle, so to speak. And that culminates with an oral argument. So the way, in my mind, to get them ready to handle a pending U.S. Supreme Court case is a dispositive motion, like summary judgment. So I plucked these 2 quotes out of Charles's book, as well as, this isn't Mary Beth's book, but one of her earlier, I think it's earlier articles. And I love that it's basically kind of top down on the slide as well as bottom up. Because what Charles points out is that summary judgment, okay, yes, it's stimulating, and yes, he calls it a brief. I think of it as a memo, but it could lead to the longer brief. But the key thing for me is that the student must, quote, remain constantly sensitive to the merits of the underlying claims, right, the substantive claims. At the same time, they're dealing with the procedural overlay of summary judgment. So right away, that's just great, I think, conflation or congruence of the procedural law that they're getting in Civ Pro in their first year, but that don't, rarely, at least in my school, they don't put into practice. But I'm also helping them to understand some substantive law, how that procedural law applies. And then Mary Beth, right, is taking it from the opposite corner, which is students work from the bottom up, right? Teachers present the students with a set of facts, ask the students to research like a lawyer, think like a lawyer, and write like a lawyer. So let me give you some perspective on how summary judgments are used, well, how we use them at VLS. So I noted at the top, diversity of doctrinal law, common approach via summary judgment. So these are two of my colleagues. Brian Porto's here too, and he does a summary judgment motion as well, based in, no.
It's Title IX.
Yeah, Title IX. But what I did, I have to be honest, this presentation came about because I really wanted to improve, in particular, my record and how I use facts in creating the summary judgment motion memo this semester. And so I thought, you know, I'm going to sit down with a couple of colleagues and talk to them about how they do it. So Hillary does hers in federal grazing law. That's a background that she brought from practice when she came to VLS. Tony does a Title VII employment discrimination case. And I focus mine because my students, so students enroll in this class. I have to tell you this is my favorite story about how students perceive this class. You know that it's a required class. But students get to choose which section. So they come thinking that they chose the class. It's this amazing sleight of hand. They're such happy campers from day one, you know, because they get to choose to learn these skills in the context of natural resources law, or one of my colleagues does state constitutional rights. Tony does federal constitutional litigation. Brian's doing Title IX and sports law more generally. And mine is based in environmental health law. So you can see I'm third on this list here. So RCRA is the Resource Conservation and Recovery Act, and it's a groundwater contamination case. But all of us, a common denominator at the bottom here you see of the slide, is students receive a case file that they're working with. An array, I should say, between the three of us of messy facts. Some less messy, some very messy, meaning lots to deal with and very raw. Second, the students then are put in the position of representing that client, so either writing a memo in support of the motion or in opposition to. And then third, they all do an oral argument on that motion. And I should be clear, it is not patterned on real motion arguments. That's a little too wild and woolly. Instead, we all pattern it more on an appellate argument, so it's a little more structured. Any questions to date? One of the things in thinking through this presentation today, rather than giving you kind of turnkey handouts on each of our fact patterns, you're welcome to contact me and I'll put you in touch with my colleagues, in particular if there's a doctrinal area that really interests you, as well as sharing my own materials. But what I really wanted to do, I sat down with each of my colleagues and did an interview last 2 weeks. Meanwhile, we were doing appellate advocacy arguments at night. So it was always good to catch them about 4:30, offer a cocktail, and we'll chat about what we do in legal writing too. But I actually had a systemic list of questions, and they were essentially on the advantages. Why do you do it? Because we have the choice. We don't have to do a dispositive motion, legal writing 2, to introduce persuasion. We choose to. We have one colleague who does a state appellate brief. That's his choice, and that's within the parameters of our program. So when I asked, why do you choose it? The number one answer was more realistic of the practice of law. At least in the short term, it's more likely our students are going to go out and argue a summary judgment motion on either side than it will be an appellate argument, even at the state level. Okay, again, reminder, we set up our students to think that they're going to the U.S. Supreme Court the first time out based on their schoolwork. So more realistic. I think it was Hillary who said, I think she used the Lincoln Town Car, which was pretty funny because most of us drive either Priuses or Subarus in our corner of Vermont. But she was saying, this is the workhorse of persuasion and practice, and that's what I want to introduce to students. So very practical, practice ready that way. The other thing, and Tony, the quote comes from him on the second one, helps students understand the incomplete universe of facts. I think one of the things we've done early on when legal writing programs were first started in the 70s is we took a lot of indeterminacy out of it. And I think one of the things we've done decades later is introduce that back into it, that students realize there isn't one answer. As I said, if there were, we wouldn't be arguing it. That one is done. Either it's not a case or somehow it was settled early on. But instead, what Tony does in particular, and I brought my Exhibit A. This is Tony's case file, complete with pages and pages of depositions. Messy, raw facts, as he likes to call them. And he does that purposefully because, and I love his curriculum, he actually keeps this client most of the semester So the students start out essentially interviewing the client, role-played, and I'm sure many of you do this, role-played by usually third-year students, folks who have taken your class, go through the process of trying to settle it, then writing a demand letter, and then get to this point of posing or opposing a summary judgment motion. In contrast, Hillary has taken deposition, mostly deposition transcript pages, and condensed them and given them more in a narrative form assigned by the senior partner. My materials are based on what was then live litigation that our Environmental and Natural Resources Law Clinic was doing about 6 years ago. And in fact, what I wanted to do is have my students research live, do some research that would help the clinic in its work. So just basic research, but then we would take that back into it and model it into our own persuasive argument kingdom, I want to say, but our own little corner that was not real. So we made it unreal at that point. The fun part about that is that that case morphed about 3 times in the course of the last 8 years. It's still going on. My students still know this defendant's name, but the case is almost completely different. So what's fun is I bring in attorneys who, there's been changes, of course, over the years, but I bring in sometimes student attorneys, the third years who are working in the clinic on the case, or I bring in some of our senior folks, and they talk about how it has changed over the years, which is a great perspective. I think I'll just jump down to the last one, embodies how the process of writing fits within the process of litigation. Partly summary judgment, great, you know, you can see it from, my students get a complaint, they get the answer, they get some materials from different experts because it's largely about groundwater contamination. So we have to go through those messy facts. We don't try to negotiate it out at all. We go right to the summary judgment motion memo. But at least they see the litigation process kind of in the unreal world of the approximately 6 weeks of the second semester that we work on this. But then also when I bring in someone who's working on the real case, they can see it over the last 6 to 7 years of litigation. A couple other things. I can't stress enough, even though I think at some point in the semester, both the students and I both blow a gasket on this, but the whole idea of overlaying procedural law and substantive law, it just doesn't seem that complicated to me, but it always is a challenge. And my joke now, they laugh at me, but I say, you know, when I was a little girl in the late 60s, early 70s, my dad bought encyclopedias from a traveling salesman who came to our door, and every month we get a new volume, and it was in a bookshelf at the top of the stairs outside our bedrooms. One day, I discovered the volume that had the human body. And I wasn't just looking at the sexual, reproduction system. What I loved about it was that it had, I think, the skeleton at the base, and then there would be those clear overlays. Oh, good! You're my people. I love it. My students are like, do you have an app for this? You know, I'm like, I don't even have a cell phone. Okay, but I know what an app is. That's good, right? That earns me points. Issue spotting, app, something modern. So I tell them about this, and I said, so imagine that RCRA, the imminent and substantial endangerment part of the citizen suit provision, is this underlying substantive law. And then the Rule 56 requirement, right? No genuine issue of material fact, judgment as a matter of law. That's on top of it. And let's break it apart. And actually, someday I'm going to create some visual that shows this. You know, I've yet to accomplish this. Anyway. You're right. I keep thinking that I'm going to do it on the screen and kind of show the page over, but you're right. I could probably dig one up someplace, right? eBay. But I really want to stress that piece of it. That's what I really love about summary judgment. Certainly when I teach appellate advocacy, I talk about standards of review. But for the most part, especially because we're using live pending U.S. Supreme Court cases, it's mostly de novo. So there's not much going on there procedurally. This fourth point I want to argue to you as an advantage of using summary judgment motions is one that Hillary really pushed with me about, because I argued, well, you do discrete, factual analysis, applying facts to different parts of a rule in an appellate advocacy case as well, right, an appellate case. But she really pointed out by using a pretty messy set of facts, right, not canned, not already passed on by usually a district court judge and appellate judge, that this gives them a chance to really discreetly break apart the parts of a rule and then help students understand relevancy, basically. Okay, downsides. No, the challenges. Actually, these are some clinic students from the Environmental and Natural Resources Law Clinic in a Newfane, Vermont courtroom. They really are. Isn't it pretty?
It's all boys.
Yeah, well, the next time you're on our webpage, folks, take a look at the faculty in the Environmental Law Center. You'll find similar, quite a few boys.
Okay.
Don't know why that is.
Just boys like environmental law.
I don't know. More than half of our class are women these days, right? The entering class. And most of them come to VLS because of our ranking in environmental law. So good question. I can tell you that one of my TAs right now is a current clinician there, and she's not only a girl, she's a pregnant girl. So she's really a girl, right? Woman, excuse me. Okay, so the downsides. One, Tony will tell you this, maintaining this file. Right? It's work. And it's, if you're going to use live messy facts, then you're constantly looking at them again and at a minimum updating them. Second, what I said, the flip side, I love teaching the circulatory system on top of the skeletal system of Rule 56 on top of imminent substantial endangerment and RCRA. The downside is doing that. But what I will argue, again, on the upside is usually the students have just started Rule 56 in their Civ Pro class that semester, the spring, and either they're learning it at the same time, and I happen to co-teach a seminar on genocide with one of our Civ Pro teachers, so I actually get the skinny on the timing, and I sometimes try to influence it. But if they haven't gotten to it yet, when they get to it in Civ Pro, they are the experts, and there's a lot of fist bumping, yeah. Because they really have lived it for a period of time for this client. Oops, got to stop. Oh no, I'm on time for once. Yes, I haven't even gotten the 5. Wonderful. Sorry, I spent all this semester teaching a new class. I taught torts for the first time, and I was chronically late. I just felt like I was, so this is so relaxing. I'm so glad I'm in my comfort zone. So the time needed to deal with messy facts, but I think we all do that because that's usually one of our goals in that second semester curriculum. So, but it still is a challenge. You have to build that into your syllabus. And then finally, this may be the biggest one. Since you all sound like you're the converted or look like you're converted when you raised your hands, it sounds like you haven't bumped into this. But I've heard from other colleagues across the country that students and consequently faculty, or maybe faculty and consequently students, and maybe a chicken or egg thing, really expect to learn persuasion through an appellate case. That somehow we've built that expectations that persuasion means an appellate argument. So the downside could be that some folks will be resistant to viewing emotion.